Call to order the licensing committee meeting. Today is April 27th, 2015. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must sit in the audience. And if a quorum of board members are present, those members who are observing cannot participate in the discussion. So we're going to start with self-introductions. David, I'm going to start with you.
David Foe, Chief of Enforcement.
Christy Shields, Counsel for the Board.
Susan Granzella, Board Member.
Frank Shutter, Board Member.
Linda Clifford, Board Member.
Karen Robinson, Chief of Licensing.
Cindy Christensen, is this on?
I don't know.
Cindy Christensen, Registrar, and I want to take this opportunity to formally introduce Cindy Kanemoto, our new Chief Deputy Registrar. Cindy's been with DCA for quite a long time. She started off in the training office, and then she worked recently in our IT office, Chief of IT, and then she just assumed that role April 2nd.
Welcome, Cindy. And I'm Kevin Albanese, Board Member.
Obviously, Cindy.
Charlotte Allison, Licensing.
Welcome. Okay, thank you very much. I don't have any necessarily any important comments to make other than welcome, Cindy. Thank you. And welcome to our public affairs person. It's always good to have new people. And also that I'm excited about a lot of the stuff that's in the agenda today, so this is going to be cool. This is the public comment session, so if there's anybody who wants to get up and make a public comment at this time, please feel welcome to do so. There being no public comments, we will move on to the licensing program update. Karen, would you like to take that?
I would love to. I don't know if my mic's working, but I'll try to talk loud. So, again, we have in our packet the application workload, and I won't belabor this because we do have other issues that will probably take more time. On page 1, we've got the average number of applications received per month, and yay, we're up a little bit for exam apps. When we get to the end of the fiscal year, we'll see exactly how that went. And then on page 2, we've got the total number of applications received per month, and we are trending up a little bit in some areas. Then, I'm saying page 2, and it says 10 in the book. Okay, so on page 11, sorry, we've got the stats on, now it's working, on limited liability companies. Yeah, nothing's really changed. It's the same thing. We're working with them to try to get clean applications in, so we're not having to reject them. But we've made a little progress, not a lot. The workers' compensation recertification. I also want to bring up that I set a handout. Kevin had asked, could we break it out by classification, so I think you all got a handout that shows what the exemptions are for each classification, and there are also copies in the back. So, I think there are certain classes that it seems a little odd that they would have an exemption, and we'll have to look at this in more detail. In your packet, it shows the number of workers' comp exemptions that have been filed, and it really hasn't changed much since we started the recertification program. Excuse me. On page 15 is the disposition of applications received by fiscal year. It just shows, whether we issued them, voided them, or if they're still pending. And we're, I think, definitely making progress on those. I realize that you look at 12, 13 and think, why are there still 89 apps hanging out there? But there can be numerous reasons for that. Didn't pass the exam, under investigation, but we're whittling those down. Then the fingerprint criminal background unit stats are in there. I don't think I need to go over those. The experience verification unit, that's our new unit we've talked about a little bit over the past few meetings, and later in our program, Betsy is going to go over the criteria that we're using. We're trying to really make this consistent across the board, and she's worked very hard on putting together that criteria and like a matrix that people can use, because we don't want this to be some kind of big secret to our applicants. We want them to know up front, here's what's going to be acceptable and here's what isn't. Then,
Kevin, at the last meeting, you asked if we would put together an experience verification by classification so that we would know by license where we were seeing, the impact the most, and that chart is brand new on page 19.
and of course, yes, talking about that chart, you'll see that the general building classification have the highest numbers, which is no surprise because that's the majority of our population. So, I'm sorry.
Do you want to comment on?
Yes.
The only thing that I would point out on page 19, when you look at that, of the 372, only 29% of our applicants had verifiable experience. That's how I'm reading that?
That's correct.
So, in looking at that, does that extrapolate, because this is a very, very small subset of those applications, does this suggest that we should be seeking authority to expand the license verification or the experience verification beyond just the 3% or what we're doing today?
Go ahead. The 3% is what we're mandatory, we're mandated to do.
Right.
The board could probably, on a recommendation, increase that. I don't think there's any question that, as we started to do this and then chart this, that at least the numbers were higher than I thought that they would be. And I know at one time there was discussion of increasing the numbers, and I think we can do that. The board would have to agree to do that, but I think we don't need any legislative approval, I would think. Christy, you'd probably be the person who would verify that, but we have to do the minimum, which is the 3%. And I do think there's a lot of telling information in here. It was higher than I thought.
Yeah, I don't think there would need to be any kind of a legislative amendment in order for you to do it on a discretionary basis. It's an investigative tool, and I think you could do it if the board, recommends that the staff do it or directs the staff to do it.
Okay, moving on. And yes, we have a mandate to do a minimum of 3%, but that doesn't mean we couldn't up that to whatever. It's a matter of resources and, where the board wants to direct those resources. Okay, so then we've got our judgment unit, the outstanding liabilities. We've got the charts of the money that we were instrumental in collecting for outstanding liabilities, which is usually franchise tax, EDD, and then judgments, the bond payment of claims, and the amount of savings to the public. And at the bottom of page 25 is the total amount that we have been instrumental in collecting Following that is our number of weeks for processing. We're staying pretty good. We've struggled in a couple of areas. It's really kind of a staffing thing, but we have definitely been working on that. And that is the licensing update. Unless there are any questions from the board or the audience.
Do we have a lot of vacancies right now?
We do not have a lot of vacancies, but we've got a few. I think we have about 6 in licensing, but in certain areas we have one person who handles that.
Right.
So if that person is out or, whatever, those stats will end up going higher. We've been working really hard over the past several years, cross-training people so that when that does occur, we can redirect somebody.
Okay. Tessa?
All right.
The testing division has 46 exam programs. And in the last year, we scheduled over 31,000 exams at our 8 test centers. And all of our test programs are currently on a 5-year cycle for their occupational analyses. This is important to show that our exams are current. We have, at this time, 7 exam programs in the occupational analysis phase and 9 in the development phase. We just released last month a new C36 plumbing exam. And in testing division, we also develop and administer civil service exams, certain ones for CSLB. So just this month, we administered the management services technician exam. Are there any questions I can answer? Oh, I forgot to say the update starts on page 33. Thank you.
So let's talk a little bit, if we don't have questions about those 2 sections, and we may have a little bit more discussion when we get to the objective experience issue. I think there's a fuller discussion to be had at that point before we think about increasing. It may be that there's other things we can do from education or something else. But moving on to the strategic plan objectives, which start on page 39.
Oh, I'm sorry, I skipped over. I'm
Yeah.
sorry.
Okay. On page 39, yeah, I probably would have done those off. But anyway, on page 39, we have the strategic plan, and some of these are related to testing. Some of them are related to our ability to do online submissions, online payments, and things of those nature. Those are or have been wrapped up with the Breeze, project. And so there's going to be, we're somewhat constrained because that's not going forward, or we're not sure exactly where that's going to go, I guess. And so in talking, I think we're going to be looking for some alternatives, but we want to be careful that we're not investing a lot of resources outside the idea of if there is a global IT solution at some point, right? We're going to want to be able to work within that. Then the reciprocity is in here. Karen, why don't we go ahead and just go down the list? If everybody has any questions, otherwise I think they're relatively explanatory. And I think what we want to do is have a motion to move them forward as part of the overall strategic plan of the board. So we move these forward as the ones that are coming out of the licensing committee.
Right.
Okay.
Thank you. Many of these, most of them, have been approved by the board, and we're moving forward with these objectives. But there are a few on here that we're proposing for our 2015-16 strategic plan. So I'm going to go over a couple of them, and then Wendy, I think, will go over a couple as well. The first, I don't know, 8, 9, we're on our existing plan other than the research, the national contractor examination. Wendy will go over that. But what I'd like to talk to you about is the review of our current reciprocity agreements. We have agreements with Utah, Arizona, Nevada. Do we have a fourth one? No? Those, okay. But it's been a long time since we not only reviewed those agreements, but whether or not there are other states that we might want to enter into agreements with. So our recommendation is that we do some research and review of the other states, of our existing reciprocal states, and bring back to the committee and ultimately to the board a recommendation of how we move forward from there. Then determine the feasibility of a tiered general building license. I think that, and I would recommend that the time is right to start researching this. General builders, and in many states, they are tiered. They're commercial as opposed to residential. There's handyman, or what we call here the mini B. I think the time is right to look into, to at least research whether or not we should have this tiered program. Many times we have individuals that apply for a B, but they really don't have structural B experience. They have more of a handyman experience or a home improvement experience. So that's our recommendation at this point, is to at least start looking into this and bringing a recommendation to the board. Then the last one's Wendy's, the fully implement score. So Wendy, do you want to talk about the ones that you've got on here that are new?
Objectives 1, 2, and 4 are mainly about security, and they, as Karen says, they've come up before. If you refer to Objective 3, research national contractor examinations, it's important to know what's out there so that we can stay current, in fact, ahead of what other states are doing. So we want to be looking at that. It's not something that takes a lot of time to research, short-term kind of project. The really big one is number 11. That's the fully implement score 2.0. A few months back, we fully implemented score 1.5. That was keeping us current with the software and hardware requirements. But really, SCORE, our custom software, is essential to exam development, maintenance, and administration. And it's time for a little facelift. So we would update and enhance the functionality of that, and that's a very high priority. Thank you.
So 1, 2, and 4 are ones that we're just continuing to progress on. 6, 7, and 8 are related to the Breeze project, and we really, and I mean, Cindy, you've got that background. We're going to need some help to figure out, because these are all things that would make it more efficient to be able to license people and give them more information digitally as opposed to always having to staff that. So I think they are important, and we shouldn't get totally trapped by what's going on, with Breeze, or not going on with Breeze. I think 5 is super important for us to talk about. This is the experience issue that we're going to talk about next, which has to do with this entire license, this experience verification situation, which I think is really, it's important, and it's somewhat concerning. And so the reciprocity agreements, I've done that. I mean, Kevin, you've probably done that too. I don't know if you have licenses outside of California, but I've used the reciprocity in Nevada, Arizona, and Utah, all 3 of those states. And it is important. It's a benefit. The home improvement I just think that, you know, we're going to have to figure out how to make it different than a B, because it's so hard to get a B. You know, that we can't be denigrating those that have already made a lot of effort to get a B in the past. But I'd be interested in knowing what the committee thought about that. And I'm assuming we agree with moving SCORE forward. I mean, all of us who have seen it were really impressed, and think it was a big, big step forward. So I think we want to continue to support that in terms of the testing. But again, committee members, comments?
I have concerns about the item 5, the application experience, for sure. You know, we can get to that, but I'd like to discuss it.
Yeah, on the B, and maybe I'm going to demonstrate my. Is there a structural requirement in the statute for a B? Because isn't it just 2 unrelated trades?
It's 2 unrelated trades, not including framing, but we have always, our position has always been that the structural aspect is a critical part of it. You have to do the structural and 2 unrelated trades. I mean, when you think about it, when we were handing out a B license, that person can go build a house, an office building, an apartment complex. So just because you have experience doing plumbing and painting doesn't make you qualified to build a home. So yes, it's not perhaps specific in the statute that it must be, there must be structural, but that's always how it's been interpreted. And there are a number of people that, they do minor home improvement. They might go install your ceiling fan or new garbage disposal or paint a living room, but it exceeds the $500, but that doesn't qualify them to build your home. So we're just talking about looking at, is there some other category we can use to bring these people into the fold, because we want to protect consumers. You know, even if the job's only $1,000, you know, I don't know about you all, but $1,000 to me is a lot of money, and I want to be protected when somebody does that work. So this is just really a recommendation that we start looking at this. I'm not saying we have to do it. It's just let's look at it and see if there's some other way.
I mean, obviously, it's your painter contract. Sorry. It's not as if you can't get the work done, right? But perhaps this handyman home improvement concept, you could build a framework around it that would make it easier for, again, to get more licensees and to make people, you know, really be able to operate in the, you know, above ground economy, right? So that was the concept of it.
Yeah, so we do have a legal opinion on the B that it does involve structure. So, and where we really have seen this pop up a lot is with property management companies. They hire somebody that, you know, might go into an apartment complex and do this, that, and the other, you know, kind of, well, I'm not going to say minor stuff, but, you know, just a couple of trades, but they're not doing structural change, and they're not qualified to be a B, and they don't want to get 7 different subspecialty classifications to go in and do these things.
So this is more about doing the research to finally bring something back to the committee and see if the committee likes the idea to move it forward.
Question, would this, it would eliminate certain class general contractor from doing certain type of structural work? Would it have a dollar volume on it too, or?
You know what? At this point, I don't know. That's what we want to research. But no, we're not talking. We certainly are not talking about eliminating the current B structural classification. We're looking at how do we bring these other individuals into our licensure structure that don't have the experience for a full B.
One other on, with respect to earlier, we talked about the different classifications in the workers' comp exemption. I don't know if that's necessarily for this committee or for enforcement, but I would strongly suggest that that ends up on our strategic plan. Talk about protecting consumers. You talk about the underground economy. If you're licensed and you have employees and you have a workers' comp exempt, I consider you as part of the underground economy. And to have, I don't know too many people out there that could pour concrete all by themselves, for example. So I would, I'd like to see that somewhere between us and enforcement, really looked at and understand if in fact that's the case, that they're doing this and either using legitimate independent contractors or what, fine, but something's not feeling right with that.
I absolutely agree, and I know David will agree with you, because we've had many discussions of how do we track this down? Because you're right. I mean, even just look at like swimming pool. I don't know anyone who builds a swimming pool all by themselves. So it is something that I think licensing and enforcement can work together to try to, crack down on this. Are we going to get everybody? No. Some people aren't going to play by the rules, but there's got to be a way that we can narrow this down a little bit. So I think that would be a great objective for us going forward.
And just to follow up on that, the Hoover Commission that was one of the highlights of their thing and David worked on that on the Hoover Commission, is that exactly what you said. So this is in front of everybody as a big deal, and you're right, it needs to move forward. Having said that, go ahead, Susan.
I have a comment. It has to do with Breeze and 6, 7, and 8. So how is it that we're getting information about where we stand on alternatives? Obviously, we would want an update with Breeze, but what do we really need to do, and what are the highest priority things that we can accomplish, and how far have we gotten, and when will we get another update? So that would be great to hear. Okay.
I'm working really closely with the Chief Information Officer at DCA to understand how Breeze and where we're at in Breeze is affecting this board. And we've gotten some approval to move forward and explore our alternatives as it relates to online processing, expanding more of the payment options. So we're going to continue to move forward, do our own cost-benefit analysis of what will we need as far as an IT solution as compared to what is out there and available to us. So just continuing to move forward. Mm-hmm.
Based on that, let's just keep it on the agenda for the licensing committee as we move forward, okay? So I'd like to ask, and if there's no more discussion with regards to the strategic plan, these 11 initiatives, and certainly we could talk about them all day long, but I think they really are on point, and they're right. I'd like to get a motion to move this towards, I'm sorry. I'm sorry, I didn't ask for public comment, so can I encourage public comment with regards to these strategic initiatives?
If you do the motion, you're still going to have to ask for public comment again before you vote. So, okay.
Through the chair, I'd move to adopt these 11 with the addition of continued research and working with licensing on the workers' comp exemption.
I'll second it.
That will make that adoption and put that into 12. So we'll actually have 12 initiatives going forward. Is there any public comment with regards to the motion? Is there any discussion at the board with regards to, or the committee with regards to the motion? Do we have to take roll call? All right.
Kevin Albanese.
I'd like to ask Betsy to come up and talk about the table of acceptable supporting experience documentation. I think that's really critical for us to get this right and then somehow to educate so that we can get ahead of this experience issue, because this is a real problem, obviously.
Okay, thank you. So as you all know, applicants have to have 4 years of experience within the last 10 years as a journeyman, foreman, supervising employee, or a contractor. In recent years, the Enforcement Division's Application Investigation Unit had a list of 14 acceptable items that they used to request from applicants to support their claimed experience. So Licensing Division has now taken that list and expanded on it and added detail. And as you can see, starting on page 43, we added 3 columns to the right of the documentation type. Those are the types of settings that experience may be gained under, and it corresponds with what's the applicable or most likely setting where the documentation would be useful. The purpose of the document is, as we've discussed, to provide applicants with information on what may be requested to support their application and their claimed experience. We want to include it as part of the application package and on the website. California Code of Regulations Section 824 allows the board to approve such a list and then to make it available in those 2 forums. And this will give applicants information before they even apply, so they know what could be requested of them when they get into the application process. Okay, thank you.
Oh, I have just a ton.
Okay.
I'm sorry. And I'm not trying to pick on you, but I'm having a real problem with the 4 years experience of a journeyman, foreman, supervising employee, or a contractor classification. I can understand some of these are pretty straightforward. You're requiring apprenticeship documentation, but under the Department of Apprenticeship Standards, many of these are apprenticeable crafts and trades, right? And that requires 8,000 hours of apprenticeship before they reach a journeyman level. So we're asking for 8,000 hours of experience on the journeyman level. Are they verifying their training? That will require a total of 16,000 hours for most of these crafts, which is 8 years total experience from start to finish, to be able to qualify for our test, as I would understand it. And some of these things that we're asking for here, like wage or tax documentation, I mean, some of the stuff kind of smacks to me as being some guy that worked on his garage, some person that worked on their garage, and they're going to add that as non-trained, basically experience as part of journeyman hours. If they haven't qualified to be a journeyman to start, how do any of these hours qualify for anything?
First of all, if somebody does go through an apprenticeship program, we can grant up to 3 years of credit for the apprenticeship program. So then they would just have to have an additional year beyond that. And all of these documents are just documents that could be requested, not that they're required, but they could be requested to support a certification of work experience. So everybody has to submit a certification of work experience. And then the documentation may be requested in support of the claimed experience.
I understand what you just said, but
Okay.
it says a minimum of 4 years work experience as a journeyman or a foreman.
Right.
That doesn't include 3 years as an apprentice. An apprentice is not any of those things. An apprentice is a person who basically starts his first year and knows nothing. And by the time he reaches his 4th year of apprenticeship, by the apprenticeship standards, they've passed tests and they've had 8,000 hours of field experience to qualify to be their first day as a journeyman. So 4 years journeyman experience would be after that. So you would have 8,000 hours experience after you were out of an apprenticeship program. And my point is, how are we, with any of this documentation, except for the one that basically talks about either working for a licensed contractor, you could document those hours, or the ones talking about submitting apprenticeship records. How would we know that any of these people were trained to do any of this work that they're trying to document?
We are relying on the certifier on the certification of work experience. Ideally, it's a licensed contractor who's certifying. But the I know you were saying that apprenticeship plus journeyman gets them to 8,000 hours, but if they have an approved, completed apprenticeship program, they get 3 years of credit for that. So somebody who does fully go through the program, they only have to have an additional year at journey level to be eligible for licensure.
So, Frank, just a second. Betsy, should the wording here be a minimum of 4 years of work experience as an apprentice, a journeyman, a foreman? Because if we're saying that that it has to be as a journeyman, Frank's technically right about the math. In other words, in order to become a journeyman, all the programs have different periods of time. He's talking about the one he's most familiar with. It takes 4 years to be an apprentice, then you're a journeyman. It doesn't say here that your work experience can be as an apprentice.
Linda?
So should the wording?
If I may, I believe maybe what it should say is that you can substitute an apprentice program up to 3 years towards the 4 years of experience. So basically, if a person has gone through an apprentice program, they can take that 4 years and they can substitute they'll get 3 years of credit that they can substitute towards the 4 years, and all they would need is an additional year after the apprenticeship program. Does that kind of clarify it?
Right, but it doesn't.
But we can include that.
Just fix the wording.
Yeah.
It's just that the wording is taken directly from the
Statute,
Right, the
It's
statute and
825
regulation.
of the Business and Professions Code that actually says that every applicant must have had within the last 10 years immediately preceding the filing of the application not less than 4 years of experience as a journeyman, foreman, supervising employee, or a contractor in the particular class within which the applicant intends to engage as a contractor. So this language tracks what the law requires the board to do. But I think Ms. Christensen's explained how you would count that in order. But I don't think that changing the language would be a good idea, because then you'd create an inconsistency in the law, and a conflict between what you're doing and what the law requires.
But
So-
is this table in the business and professions?
No,
Okay.
what we're,
You could do it in the table.
well, yeah, what I think we're asking for at this point, the staff's asking for, is 824 requires the registrar to provide to the board for its approval acceptable forms of such documentation, and shall inform the applicant of that documentation requirement. So this is being provided to you for your comment on whether you think that that would help satisfy the 4-year and the 10-year requirements. And that's what we're asking you to do, is explain if you think that there's any problems with the types of evidence you're requesting, or if further evidence should be asked for. That's what we want your input on. That way, then it can be presented to the board for its approval, and then the staff can use it in the application process.
My problem with this is basically the way that we're calculating who's qualified and who's not. In all the apprenticeable crafts, whether that we give them 3 years or not, we would be saying a apprentice that basically, or a person who was in training for 3 years, we gave them credit for that. They would then, let's say, have dropped out of their apprenticeship program for failure or whatever reasons. And basically, they could work another year, and that would qualify them to be a contractor.
No.
Yeah, that's what
Frank,
we
it
said.
doesn't. It says proof of formal apprenticeship, and it should be completion, in other words, it should be, it's just not proof of it's page 46 at the top. It says proof of formal apprenticeships in related construction trade, including those administered by unions and vocational or accredited schools. So it should be proof of completion, not just, not I entered into the program. You actually have to complete the program and be certified by that, whoever that provider is, right?
That's right.
Then, if that's the case, you would get these 3 years of credit, and you would have to have that 4th year as a journeyman, foreman, whatever, right?
Question to you is, so you think the certification would be the proof that the board would need to satisfy this requirement?
From this third-party provider, whether
Okay.
it's a union or a vocational school, or an accredited school I teach HVAC or whatever. But yeah, I think it's, when you say proof of formal apprentice, it's got to be proof of completion of the program.
And I would absolutely agree with that, and that is how we do it now. They have to have proof of completion, not just that they were in it for a year or two. So we can add that, proof of completion of formal apprenticeship.
I would request that you include the certification element, because whenever you say proof, it's a little bit ambiguous with respect to what actual proof you're requiring. Yes.
The document that's required, the actual document, is a certificate of completion. So I think we're mincing words. I think if I understand Frank's concern, it's the granting of credit for while you're an apprentice, but we also grant credit for 4-year colleges and whatnot. So I think there's some precedent there. I think what's important for the board and for this committee to remember, and I think Steve Sands said it best, it's very important. It's the applicant that has the burden to prove their years. And when we look at the statistics showing only 29% of those applicants that we looked at had verifiable experience, I think this is a great start. I think we put it up. But I think our goal is to license everybody that we can that desires to be licensed, yet at the same token make sure that we're only providing licenses to those that have done that. So with that being said, I think the list is comprehensive. I think it's pretty detailed. I don't think this locks us into this is the only documentation that we'll accept. I think we need to be, willing to consider, and have the opportunity to ask for. So with that, I would move to accept this table of acceptable supporting experience documentation as submitted.
You're a little bit ahead of me, Kevin. I still have some questions about this. We breezed, the law is pretty specific. It says journeyman, foreman, supervising employee, or a contractor in that classification. It does not allow for any apprenticeship hours. These are persons in training. They're asking for 8,000 hours of experience, of journey level of experience or higher. That's what we're asking for here. Has nothing to do with apprenticeship training. Apprenticeship training just puts you on the road to be a journeyman, to basically qualify for one of these jobs we're talking about here. I have a real problem with taking copies of deeds and proofs of sale on applicants' own properties as proof, material receipts. Be honest with you, a 4-year college degree is fine, but if that was in liberal arts, I don't know how that really qualifies somebody to be a contractor. And what I'm concerned about is not what are we doing to the public when we turn one of these people loose that don't have enough experience, to the point where we're talking about splitting the B qualification because of structural and everything else. I mean, personally, when I got a license, you had to have documentation for 4 years of apprenticeship, 8,000 hours in one of these classifications, and you had to have a sign-off of 2 other contractors. Now, I realize that's probably a little extreme because you're asking your competitors basically to sign for your license. But I think these 4 years of experience as a journeyman foreman or supervising employee or a contractor in another state are critical to make sure that our public is getting what they're expecting for. We hand somebody a license, and I can guarantee you that when the public sees that, they expect they're fully qualified to do whatever they have, whatever project that licensed person is qualified to do. They expect them to have knowledge of all these things, and I don't see it with what we're requiring here. To be honest, I think it's way, we've wanted to license people, and we've gone way too far to do that.
Frank, on the education, it is only a construction-related education. So I think the education piece is fine. I'm open to continue that discussion. We don't have a second for your motion at this point, so motion's going to fail for lack of a second, I believe. And
Can I just add about the apprenticeship? It is part of the California Code of Regulations, Section 825D. Acceptable training in an accredited school or completion of an approved apprenticeship program, in the construction trade for which the application is made will be counted as experience, and in no case will the training or apprenticeship program count for more than 3 years of experience. So it is in the law, and it will be counted as experience. So we do I don't know that there's discretion for that.
Is there a conflict between what's written in the part you were talking about in your section?
The same section was.
I keep forgetting. 825, the introduction says the 10 years of experience. And then later on, the acceptable training that she mentioned is in subdivision D, so of the same regulation. So from your perspective, you see that as a conflict. Is that what you're saying?
If the minimum of 4 years experience as journeyman, foreman, supervising employee, or contractor is an apprentice, yeah, I would see that as conflict.
I think, and I haven't been here that long, so I'll defer to staff on this, that I think it'd be in addition to other experience that you would count for the total time in terms of analyzing whether someone's qualified. So that would just be a part of their qualification. Am I correct, or?
You're absolutely correct. And believe me, Frank, nobody takes this more serious than the licensing staff. We want to make sure that the people we're licensing are qualified, and we want to make sure that anyone who's qualified gets licensed. But I understand where you're coming from, and we take every step to make sure that those that we're giving a license to actually have the qualifications. But the law does allow for us to grant, actually says we will grant experience for apprenticeship and for certain education.
I think what's important also is we have a lot of schools who are training people to, take the tests and to get qualified as a contractor, and we need to give them as much help as we can to get the right information in, because I think a lot of this comes through with, let's just hope for the best. And with this list, we just need to have a full push on education, where this becomes part of what the schools hand out when someone comes in and says, okay, great, you're going to help me pass the test, but you've got to have this experience. You can pass the test all you want, but you're never going to get the chance to take the test if you can't get past this hurdle. So we're trying to be as helpful as we can to get people to find a way to, and it is a combination. It's never one. And the law even doesn't allow you to get fully qualified on education or fully qualified on apprentice. So it is always a combination. I think if you made your motion again, you might get a second.
Well, the only thing I would ask is that the staff clarify about what proof they're actually asking of the applicants, because the regulation requires the board to approve the acceptable documentation. So just saying proof of something doesn't say what kind of document needs to be submitted in the application to support the qualification. So on out-of-state proof of employer's licensure, proof of employer's out-of-state license status, I assume that's a certification of license status from the other state board, or I don't know. That's the kind of stuff that I would request the staff clarify, just so that when it comes before the committee or the board, then they can actually approve the documentation itself as required by the regulation. Does that make sense?
Yes, and
Okay.
we can make it more detailed in relation to the actual, like the example you were giving, the out-of-state. But out-of-state licensure can also be verified by going to the website of that out-of-state licensing body. But we can make it more specific. Absolutely, we can make it more specific to what documentation would be acceptable for the applicant to submit.
We want to move this forward because it's important to get it out to the public. So I'm trying to figure out what the logistics are going to be for us to move it forward while still having you perhaps give us some samples or clarifications.
I have a suggestion. Why don't you just direct, if you like it, maybe just structure the motion so that you support the concept, and have staff work with legal counsel on what constitutes proof, and also perhaps look at notarized certification of work experience, which is on top of page 44, because all notarization does is just says, that's you.
That's right. It doesn't verify that the documentation is true or accurate. That really comes from a self-certification.
Well, I got a motion and a comment. This has been going on for a while, and I think what's important is to give staff some flexibility in looking at this. And we're getting all sorts of different verifiable experience, whether it's from another state, whether it's from a contractor. I mean, the cleanest is when you get the certification from his or her employer that's a licensed contractor and go through. Regretfully, part of our mission is to try to bring people from the underground economy into the above ground legitimately with legitimate verifiable experience. And I'm pretty comfortable that this gives staff enough direction. It gives the applicant enough breadth to be able to prove his or her verifiable experience and move on. And I think what's important to remember too is we're verifying minimal qualifications. I mean, we're setting a floor. Just because I have an A license doesn't mean I can go build a wharf, even though the state says I can, vice versa. So I would reintroduce my motion and ask politely for a second from the committee to accept the table of acceptable supporting experience documentation.
Second.
Can you restate the motion for the record, though, please?
I move to adopt the table of acceptable supporting experience documentation as found at page 43 of the packet. I'm assuming to the full board?
Yes.
To the, yes.
And you want us to work with legal counsel?
To the extent you need to, yes.
To the extent that staff needs to work with legal counsel, that's fine. Second to the motion. Is there any public comment to this matter? Is there any further board comment to this matter? Would you please take the roll call?
Aye.
Aye.
No.
Sorry. There being no further business in front of this committee, I will ask for adjournment at 9:25.
So moved.
Second.
We're going to
Thank
take
you.
a quick 5-minute break so we can set up for the next committee.
Right. Legislative is next.